Welcome to the deep dive. Today we're tackling a really crucial and pretty multifaceted issue: how mental health, the law, and our fundamental human rights all intersect.
It's a huge area.
It really is. We've gathered a range of sources for you, everything from, legal and medical perspectives to policy analyses and discussions around key international human rights frameworks. Specifically, we're looking at the UN Convention on the Rights of Persons with Disabilities, the CRPD, and also the European Convention on Human Rights, the ECHR.
Both really critical documents in this field.
Absolutely. Our mission really is to unpack the core challenges around reforming mental health laws, the ongoing debates about, well, when and how compulsory treatment can be justified.
It's always controversial.
Always. And also the evolving understanding of a person's capacity to make their own decisions in this very sensitive area. We're aiming to distill some surprising facts and really get to the heart of the matter.
Sounds good. Let's maybe start with something foundational: access to justice. Individuals with disabilities, and particularly those with mental disabilities, often face these silent hurdles within the legal system.
Okay, yeah. Silent hurdles. What kind of barriers are we actually talking about here? It's not just about, like, getting a wheelchair into the courtroom, is it?
No, absolutely not. I mean, that's part of it, physical access. But what's really striking is the potential for ingrained biases, stereotypes coming into play.
Right.
Our sources point out that individuals with disabilities could be victims, witnesses, anyone involved. They can often find they just aren't taken seriously.
So beyond the ramps and hearing loops, their actual credibility gets questioned,
Exactly. Their credibility itself can be unfairly doubted.
which just seems completely counter to that principle in the Equal Treatment Bench book, doesn't it? The one that says all witnesses are presumed competent. You'd think that would be the starting point.
It absolutely should be. And the bench book, actually, it gives some really practical advice on this, drawing straight from the CRPD's focused on ensuring access to justice for everyone.
Okay.
It goes beyond those basic physical things and suggests accommodations, like allowing witnesses maybe to write or even draw their responses if that helps them communicate better.
Ah, that's interesting.
Yeah, and there's even a specific example given of a person with an autistic spectrum disorder being allowed to have their comfort object, like a small toy, with them while giving evidence.
Wow. So it really highlights how the system needs to be flexible, more person-centered,
Precisely.
adaptable.
Okay, let's pivot slightly then. Article 16 of the CRPD that focuses on exploitation, violence, and abuse. Now, when you first read that phrase, you probably think of, well, someone else actively harming a person with a disability, right?
That's the traditional reading, yeah.
Yeah.
The focus is usually on a third party, the perpetrator inflicting the harm.
But our sources bring up a really crucial nuance. Individuals with disabilities can find themselves in situations of significant harm, real vulnerability, even when there isn't a specific person directly causing that harm.
How do you mean? Give me an example.
Well, think about someone whose mental health challenges mean they're, say, living in really unsanitary or unsafe conditions in their own home.
Oh.
It might not be neglect by someone else, but their own difficulty in, maintaining their living space.
Right. Okay. So it's a kind of no-fault situation in terms of another person's direct action, but the individual is clearly still at risk, maybe experiencing abuse in a broader sense. This raises a big question then. Should Article 16 cover these kinds of situations?
And this is where it gets really interesting and debated. The CRPD strongly emphasizes individual autonomy, the right to make your own decisions.
Okay.
So a strict interpretation might say, well, if there's no direct interference by another person, then autonomy isn't violated, so there's no need for intervention under this article.
But surely the CRPD also talks about the state providing support.
Exactly. It clearly outlines a significant role for the state in providing support services to ensure well-being. So it feels almost contradictory, doesn't it, to say someone at serious risk only gets help if there's a specific abuser.
Yeah, it does. So what are the core goals here? Is it all about self-reliance, or is it more about independence and decision-making, even if that needs support? And this idea of autonomy, is it objective, subjective?
These are the really fundamental questions we need to get to grips with, especially as we move more towards community-based care, away from the big institutions.
Which is generally seen as a good thing, aligned with the CRPD.
It is. It's a positive shift.
Yeah.
But it brings new challenges in safeguarding people from abuse and neglect. And while domestic settings, people's homes, are explicitly covered by CRPD protections.
The law has often been hesitant to step in there, hasn't it? The whole private family matter idea.
Historically, yes. And unfortunately, stigma, predatory attitudes, they still persist in the community, leading to exploitation and abuse.
And speaking of those institutions, though, our sources paint a pretty concerning picture of the abuse that can happen within them. It's broader than just physical
Oh,
violence.
absolutely. The
Yeah.
spectrum's wide.
Yeah,
It
yeah,
can
yeah.
range from staff misusing their power over residents to unchecked bullying between residents
Right.
and things like overcrowding, poor food, lack of basic necessities,
Mm.
understaffing, not enough training. They all create an environment where abuse can just
But with
thrive.
restraints.
Yes, the inappropriate use and, crucially, the poor monitoring of restraint systems is another major, major concern.
It sounds like these places can easily become environments where harm just goes unseen, unaddressed.
That's exactly it. If you don't have enough external visitors or thorough inspections, these poor conditions can just continue under the radar.
And even if problems are flagged?
Well, often there isn't the political will or maybe the resources allocated to really fix them. And the internal culture, the institutional culture itself, can be a huge barrier.
How so?
Reporting mistreatment, especially if it implicates the institution or its own employees, well, that can be incredibly difficult. People fear retaliation, losing their jobs.
It gets even more complicated when we think about people with mental disabilities who end up in the criminal justice system. There's a real tension there.
There is. You sometimes hear this uh, troubling perspective that providing humane conditions for someone detained in prison who also has mental health challenges might somehow undermine the punishment aspect.
Which is just wrong.
Fundamentally wrong. It's absolutely crucial to remember subjecting any prisoner, disability or not, to inhuman or degrading treatment is a clear violation of international law.
Mhm.
Article 14 of the CRPD makes that very clear.
And that article also says they're entitled to equal rights, reasonable accommodations.
Yes, absolutely. Equal rights and necessary accommodations within the justice system.
Now, something that really jumped out at me from the sources was this point about how limited the actual evidence base is. When it comes to violence, exploitation, abuse against people with disabilities, especially mental disabilities.
Yes, it's quite striking how openly the limitations and even flaws in the existing research are acknowledged.
In what way?
Well, our sources highlight there are just relatively few studies overall, and the ones that exist often focus on very specific types of disabilities like developmental or learning difficulties.
Oh, okay.
And they tend to concentrate quite heavily on sexual abuse specifically. Geographically, it's narrow too. Most studies come with just a handful of countries.
So we don't really have a full picture backed by solid research of exactly how abuse happens in practice, especially for people with mental health conditions.
That's the critical point.
Good.
We lack that kind of systematic evidence we'd ideally want. But, and this is vital, our sources strongly emphasize that this lack of comprehensive data is not an excuse for inaction.
Right. The problem is real, whether we've studied every facet of it or not.
Undeniably. Violence, exploitation, abuse against this population continues to be a serious issue, and states have a clear, urgent obligation to act.
Okay, so given this complexity, this lack of perfect data, what kind of guiding principles should shape our efforts? How do we create effective interventions, protection programs?
Well, first, it's vital to see Article 16, the one on exploitation and abuse, within the context of the whole CRPD. No single article is a trump card, you know. They all work together.
Makes sense.
Second, and this is absolutely crucial, protection programs must not end up focusing on controlling the person with a disability. You can't achieve a human rights outcome by infringing the very rights you're trying to protect.
Right. That seems self-defeating.
It is. And finally, given those evidence gaps we just talked about, there's a really pressing need for more and better research. We need to figure out what interventions actually work in preventing and addressing abuse. States need to be proactive here, innovate, test new approaches, rigorously evaluate their impact.
Okay. Let's shift gears now to another really significant and often hotly debated area, compulsory mental health admission and treatment. Our sources talk about different potential paths for law reform, using Hong Kong as an example, but the issues are relevant everywhere.
Exactly. The pathways being discussed really span a spectrum. You've got proposals for the complete abolition of compulsory treatment altogether.
Wow, abolition.
Yes. Then there are approaches focusing solely on risk of harm, usually to others, as the justification. Other models center on mental capacity as the key factor. And then there are pushes for more consensus-based approaches to care.
And underpinning all this is the pressure from international human rights law.
Absolutely. Commitments under things like the ICCPR and especially the CRPD really necessitate a thorough review and reform of existing mental health laws in many, many countries.
It sounds like a very delicate balancing act. You're trying to meet genuine local mental health needs while also fully respecting these big international norms about autonomy and minimizing coercion.
It absolutely is a balancing act. A core principle that comes through again and again is that detention for mental health reasons must always, always be a last resort.
Last resort.
Used only when absolutely necessary for the shortest possible time, and crucially, with robust legal safeguards. Regular, independent reassessments are key. Is detention still justified?
And just detaining someone because they have a mental health condition without them posing a risk?
That idea of preventive detention based solely on mental health status, without demonstrated imminent risk to others, is increasingly seen as just incompatible with fundamental human rights.
Now, the sources also raise some very specific worries about existing laws. Again, using Hong Kong as an example, there was this thing called the Section 42B Conditional Discharge Order. What's that and why the concern?
Yes, that's Hong Kong's main tool for civil compulsory treatment in the community, and it raises significant human rights issues. One big problem is the lack of a clear, easy way for someone to actually get off this order. Well, currently, the power to discharge someone rests almost entirely with the Mental Health Review Tribunal, even if the person's own doctor thinks they no longer meet the criteria.
So the doctor can't just say, okay, you're well enough now.
Not effectively, no. And maybe even more concerning, the order itself doesn't have an expiry date. It can just continue indefinitely.
Indefinitely. Wow, that sounds incredibly problematic, almost like an open-ended restriction on liberty and autonomy.
It is. And what's particularly worrying is that there's been talk locally of actually expanding the categories of people who could be put under this order without fixing the fundamental lack of safeguards first.
So making a potentially problematic system apply to more people.
Potentially, yes. Proposed reforms try to address this, things like giving medical practitioners the authority and duty to discharge patients when conditions are met, or at the very least, putting clear time limits on these community orders.
So what we're really seeing is this clear tension, isn't it, between established mental health laws and this growing global push towards a more rights-based approach.
Precisely. And that shift is largely driven by the CRPD's core message. Using compulsion based solely on having a mental disability is discriminatory. It's unacceptable.
So that forces a move towards
An evidence-based approach to reform. That means things like mandatory, ongoing mental health training for all professionals involved, legal, medical, social care. It means guaranteeing access to high-quality, person-centered care. And it means tackling those broader social issues, housing, jobs.
the social determinants of health.
Exactly. Our sources even stress the importance of doing mental health impact assessments when drafting any new legislation that might affect this group, or when amending existing laws.
It sounds like the role of psychiatrists and other mental health professionals must be evolving quite significantly, too.
Absolutely. There's a growing recognition they need really strong communication skills, a deep understanding of cultural diversity, especially with increasing migration.
Right, diverse populations.
And there's a need to sort of renegotiate the implicit contract between psychiatry and society. Embracing digital technology ethically and based on evidence is also key. And importantly, lifelong learning has to be central to professional development.
You mentioned cultural awareness. The sources really highlight that, don't they? It's growing importance.
Yes. What's insightful is how deeply culture can influence how someone understands their own symptoms and how they communicate those experiences.
So diagnosis needs to adapt.
Diagnosis needs to become more nuanced, actively consider these cultural influences, and treatment plans need to be culturally competent, considering beliefs about self-disclosure, locus of control, potential conflicts, or synergies with traditional medicine.
So we need investment in training, research.
Yes, targeted training, culturally sensitive research, and developing clinical systems that are actually responsive to cultural diversity. It's becoming essential.
Another key point raised was the impact of power dynamics within the therapeutic relationship itself.
Yes, the potential for abuse of authority, abuse of power within therapy, can have really profound, long-lasting negative consequences. It can even contribute to passing trauma down through generations.
So the relationship itself needs to be healing.
Creating and maintaining emotionally corrective, empowering therapeutic relationships is absolutely vital for recovery.
No, let's touch on that trend towards subspecialization in psychiatry, especially in well-resourced countries. What are the implications?
Well, more specialization can mean deeper expertise, potentially better care for specific conditions, but it also brings challenges.
Like what?
Higher costs, maybe fragmentation of care if someone has multiple issues, needing better coordination between specialists.
And that contrasts sharply with low and middle income countries.
Very much so. In many LMICs, resource scarcity forces different models. Task shifting is common, training non-specialist health workers to deliver basic mental health interventions. Psychiatrists there often act more like public health practitioners, supervisors. Integrating mental health into primary care becomes key.
Which really underlines the need to integrate physical and mental health care everywhere, doesn't it?
Absolutely. We see alarmingly high rates of untreated physical health problems in people with mental health issues. Psychiatrists need to collaborate closely with general health specialists, and they need training in managing common medical comorbidities too.
And in those low-resource settings, the situation for people with severe mental disorders can be particularly dire.
Tragically, yes. Severe shortages of psychiatrists mean people can face incredibly inhumane situations hidden away by families, sometimes even physically chained.
God, that's awful.
It is. Psychiatrists in those contexts often have a vital role just finding these individuals, challenging these practices, training local people, lay people, to provide basic support and care.
Okay, let's circle back to the fundamental principles of mental health law from that rights perspective. The CRPD really seems to throw down a gauntlet to long-standing practices.
It really does. That core assertion that compulsion based solely on mental disability is discriminatory. It forces us to critically re-examine psychiatric detention, compulsory treatment, practices that have been around for a very long time.
So the big question is, could we actually abolish these practices? Is that realistic? And if so, how?
That's the critical debate. And it's so important, as the sources stress, to center the views and experiences of people who've actually been subject to these interventions.
I need to listen to them.
Absolutely. And history shows radical shifts can happen in psychiatry. Think about the non-restraint movement in the 19th century, or deinstitutionalization in places like Italy.
Right.
We also need to rigorously question the evidence that supposedly proves compulsion benefits patients, especially when you consider that other medical specialties manage without routine legal compulsion.
The concept of risk seems absolutely central to so many current mental health laws used to justify intervention.
It does. Risk has increasingly become this key tool, almost a tool for social control within mental health law. And concerns have been raised that adding extra harm criteria for involuntary treatment might actually be discriminatory,
How so?
because it potentially creates a different lower threshold for people with mental health conditions compared to other people who might lack capacity but don't have that label.
Ah, I see. Finally, let's touch on digital psychiatry. It's advancing so fast. What opportunities and challenges does it bring in this context of law and rights?
Well, digital tech definitely offers huge potential for a more personalized understanding of mental health, for enhancing care delivery, but
There's always a but.
there is. Realizing that potential ethically and effectively needs a lot of work. Development, rigorous research to prove it works, comprehensive education for clinicians and users.
And the challenges. Privacy, trust.
Exactly. Data privacy is huge. Building user trust. Establishing clear clinical evidence. Does this app actually help? Making different systems talk to each other. Interoperability. And integrating it smoothly into how clinics actually work.
So the tech needs to serve the care, not the other way around.
Precisely. Care and user needs have to drive the technology. We might even see new roles emerge, like clinical technology specialists, to help bridge that gap.
And given the massive global gap in access to mental health treatment, can digital tools help address that?
They offer a really promising way to reach underserved populations, absolutely, to expand the reach of services. Primary care is often the de facto mental health system anyway.
Right, but often without the resources.
Exactly. Technology could potentially help boost their capacity to identify and manage common mental health conditions.
And as care goes digital across borders even, that cultural psychiatry point becomes even more critical.
Absolutely vital. As care expands through telepsychiatry, remote monitoring, respecting local cultures, local beliefs becomes paramount. It just underscores the need for that cultural psychiatry training we talked about.
And medical education itself needs to adapt too, away from just lectures.
Yes, incorporate more active adult learning methods,
Mm.
problem-based learning to develop critical thinking, collaboration, and leveraging shared, open educational resources because the field changes so fast.
It really sounds like the psychiatrist of the future needs to wear many hats, not just clinicians.
Precisely. They need to be strong advocates for patients, especially those with mental illness. They need to be leaders, driving better coordination and integration of care.
Engaging with the public mental health agenda.
Yes, proactively. Despite the challenges, resource pressures, stigma, mistrust, effective clinical leadership by psychiatrists is essential to advocate for patients and for the profession.
It's also fascinating to look back at the history here. Mental health law isn't new at all, is it?
Oh, absolutely not. The law has been involved with madness, as it was often termed, for centuries, right back to early legal codes about the Crown's jurisdiction over people deemed insane.
And impacting everyday life. Wills, marriage.
Yes, numerous legal cases dealt with capacity to make a will, to marry, enter contracts, testify in court. Confining people considered of unsound mind was never purely medical. Legal criteria and processes were always involved. Even the mad doctors, the early practitioners, were subject to legal regulation.
And how did the law historically try to determine capacity or insanity? What were the tests?
Well, for making a will testamentary capacity, the historical test required understanding the nature and effect of the will, having a general idea of your property, understanding who might have a claim on it,
Okay.
and crucially, being free from insane delusions that might skew your judgment. Actually, diagnosing insanity routinely back then was tricky, partly due to record keeping. Legal records, like admission documents or asylum case books, were often more structured.
And key legal cases shapes this.
Definitely. Cases like Waring v. Waring, Banks v. Goodfellow. In criminal law, the test for fitness to plead, being able to understand the trial and defend yourself, has been fairly consistent. The insanity defense itself evolved significantly, formalized by statute in 1800, and then the famous McNaughton rules came in 1843.
The McNaughton rules not knowing the nature of the act or that it was wrong.
Exactly. And those rules are still incredibly relevant in many common law countries today. Interestingly, for contracts, the legal focus gradually moved away from delusion being the only factor.
And the procedures for actually committing someone to an asylum, civil commitment, they varied too.
Yes. In 19th century England, for example, there was a clear legal difference between procedures for privately paying patients in madhouses and paupers in county asylums. Different laws applied.
But record keeping was mandated.
Yes. Legal requirements meant asylums had to keep patient registers, case books, admission documents, all aimed at ensuring certain legal standards were met during detention.
Okay, let's bring it to the present-day debates. What are the main justifications used now for psychiatric detention, and how do they square with the ECHR and the CRPD?
The traditional justifications still revolve around dangerousness to self or others, the perceived need for treatment, and lack of capacity.
Right.
But the ECHR says the mental disorder must be of a certain severity to justify detention, though it doesn't clearly define severe.
Then the CRPD throws a wrench in, saying disability itself cannot be grounds for detention, which seems to clash with the ECHR allowing detention of persons of unsound mind.
So there's a direct conflict there.
A real tension. There's debate now. Can characteristics associated with a disability like impulsivity be criteria, even if the disability itself can't? Some interpretations try to de-link the grounds from the disability, but that risks indirect discrimination. Fundamentally, the lack of clear, meaningful detention standards in many places is a major human rights issue.
Let's dig into dangerousness. It's used so often as a reason for intervention. It is, and it's worth distinguishing the justification. Danger to self is often seen as paternalistic, while danger to others is more about the state's policing role.
And is it okay to intervene if someone understands the risks to themselves?
That's a huge ethical question. Plus, relying heavily on someone's past history for predicting future dangerousness is problematic. History doesn't change quickly, and the tools we use, like the MacArthur scale,
They're not perfect predictors.
far from it. Their predictive power is relatively weak. They produce a lot of false positives. Which raises the question, why are such error rates unacceptable for a criminal conviction, but may be seen as acceptable for detaining someone with a mental disability? It suggests discrimination.
Okay, so once someone is detained, what about the standards and safeguards around compulsory treatment?
Well, under current English law, for example, the Mental Health Act 1983 has fairly limited external controls on involuntary treatment, especially initially. The standard used is often appropriateness, which is different from the ECHR's standard of therapeutic necessity.
Therapeutic necessity sounds like a higher bar.
It implies a higher threshold, yes. And we have to remember the potentially serious side effects of psychiatric meds. physical ones like obesity, diabetes, heart issues, and psychological ones like sedation, apathy. It's even been suggested deaths from antipsychotic side effects might, in some groups, exceed deaths caused by people with mental disorders.
That's a shocking statistic.
It is. Now, there are safeguards like the SOA, the second opinion appointed doctor, who certifies treatment after 3 months for patients lacking capacity or not consenting.
But what about those first 3 months?
That's the concern. There's a lack of robust external safeguards during that initial period when medication can be given without consent. And the shift in legal language from likelihood of alleviating or preventing deterioration to just appropriateness might have lowered the bar for compulsion.
How does the European Convention on Human Rights, the ECHR, specifically weigh in on compulsory treatment?
Okay, so Article 3, prohibiting inhuman or degrading treatment, and Article 5, right to liberty, are key here. Therapeutic necessity is the crucial justification under Article 3 for interventions that might otherwise be degrading. It has to be convincingly shown to exist.
But the Strasbourg court often defers to national courts.
It tends to be hesitant to second-guess domestic courts on the evidence, yes. But importantly, Article 3 violations can happen just based on the manner of treatment, not just the treatment itself, especially given the vulnerability of people with mental illness.
And Article 8, the right to private life.
That comes into play too. Even consensual treatment of a detained person might interfere with Article 8 rights and needs justification.
It's interesting that the sources mention relatively few patients actually refuse treatment initially.
Yes, and that many who do initially refuse eventually agree. Also, service users themselves often propose alternatives to compulsion, which professionals might not always consider.
And that difference between appropriate treatment and therapeutic necessity is key.
It's crucial. Therapeutic necessity should really involve thinking about the likelihood of success, the degree of benefit, not just whether it's a generally appropriate option.
What happens if doctors disagree about whether treatment is necessary?
That's a challenge. The courts have rejected a simple reverse Bolam test where disagreement automatically stops compulsion. But there isn't much guidance on how courts should handle that uncertainty.
And the link between capacity and compulsion.
Well, there's criticism of the idea that just having a low threshold of capacity automatically justifies compulsion. There's a difference between basic understanding and actual lived understanding. We should be maximizing actual understanding through clear communication.
The concept of best interests also gets brought up, sometimes seeming different from therapeutic necessity.
Yes, some cases have moved towards a best interests model, like under the Mental Capacity Act. That approach requires considering the person's own views, values, past wishes. It's more subjective than the often more medically objective Mental Health Act approach.
So there's value in considering patient preferences, even for suboptimal treatment.
There can be, respecting autonomy. But those preferences might still need to be overridden if there's clear, objective therapeutic necessity. Relying solely on carer's views to justify compulsion is also problematic.
And advanced decisions refusing treatment ahead of time.
That's really complex in mental health. There's a need for these decisions to be enforceable non-discriminatorily. Some places, like Ontario, have legislation addressing this. Ultimately, we need effective ways to resolve disagreements about treatment. Leaving it all to clinicians isn't acceptable. Potential bias need to balance medical and non-medical factors.
It certainly sounds like the CRPD's strong stance against coercion has caused quite a stir, even some pushback in mental health law circles.
Absolutely. Some argue the CRPD committee's very firm, almost absolute stance against coercive care has actually marginalized its views from mainstream UK practice, for example.
Seen as more for lawyers than doctors.
That perspective exists, yes. That it's more relevant to human rights lawyers than frontline clinicians. The debate continues, especially around coercion based on capacity. It's been suggested the UK might need reservations to the CRPD if it fully adopted the committee's interpretation while keeping substitute decision-making.
So there's an ongoing ethical discomfort.
Definitely. Across different justifications, clinical benefit, dangerousness, capacity, there's unease about compulsion. But pragmatic reasons often mean it continues despite these concerns.
Finally, the sources point to some worrying data and policy criticisms in the UK that really seem to highlight why reform is still needed.
Yes, the UK data shows rising detention rates, especially for Black and minority ethnic groups. Ongoing criticisms about seclusion, segregation, restraint use, concerns about safeguards for compulsory treatment,
And patient involvement.
still low rates of involvement in care planning, discharge planning, plus huge challenges accessing housing and employment for people with mental disabilities. big income gaps, very low employment rates even for those wanting to work.
And austerity's impact.
Multiple UN reports have criticized the adverse effects of austerity on people with disabilities, including mental disabilities. High poverty rates in households with a disabled member. These inequalities are framed as results of policy choices, historically treating people with mental disabilities as subjects of control exclusion.
And human rights law initially went along with this to some extent?
You could argue that early human rights law, like the ECHR, accepted this approach as long as legal processes were followed, which arguably contributed to people with mental disabilities becoming, in many ways, second-class citizens.
So as we wrap up this deep dive, it's clear we've navigated a really complex web: mental health, law, human rights, lots of intersecting issues, often conflicting perspectives.
Definitely. We've seen that inherent tension between protecting autonomy and ensuring safety or access to care. We've looked at the limits and biases in risk assessment, the evolving idea of capacity.
And what's really striking is how these different viewpoints, legal, medical, and crucially, the lived experience of people impacted, they often clash. It highlights just how complex finding the right balance is.
Absolutely. Balancing fundamental rights with society's broader responsibilities. And the history shows these aren't new debates, but the focus on human rights, frameworks like the CRPD, they're forcing us to re-examine old assumptions.
Right. So maybe a final thought for our listeners. Considering everything we've discussed, the diverse views, the history, what fundamental principles should guide the future of mental health law? How do we best balance individual rights, public safety, and access to effective humane care?
And crucially, how can the insights from international frameworks like the CRPD truly be integrated into everyday local practice? Not just stay as theoretical ideals, but actually change things on the ground.
Exactly. It's certainly a lot to think about. We really hope this deep dive has given you some valuable food for thought.